Remember, there is the mother title holding this land. All those mother titles of government land are held by the PS, Treasury. All government land, the titles are held by the Principal Secretary, Finance, on behalf of the respective government institutions or ministries that are occupying that land. The judges found out that the project started, construction started before NEMA certificate was issued. Can you imagine? The report was dated August 2025. The license to start construction was issued on 16th of December 2025, but the project started March 2025. That is a duration of over 9 months. This is in Langata constituency. What was produced in court is for Mathare constituency. The distance between Langata and Mathare, my friend, you cannot convince the judges. What is the lessons in this matter? If you have bought land that was acquired illegally, if the process of acquiring that land to build affordable housing was not followed, like the Southlands Lang'ata issue, the judges will declare that nullity, and the title deeds that you have will become a nullity. Welcome to Court Helicopter Explainer. We did an explainer about affordable housing, and we gave an indication that this affordable housing might get into headwind one of these days. And that time, the headwind Court Helicopter explained is an executive order. If the next coming president revokes the title, remember, there is the mother title holding this land. All those mother titles of government land are held by the PS, Treasury. All government land, the titles are held by the Principal Secretary, Finance, on behalf of the respective government institutions or ministries that are occupying that land. So the question that we are following yesterday, a landmark decision came out from the judges, three judges of the High Court, the ELC Court. These are Justice O.A. Angote, the principal judge, Justice C.A. Ocheng, judge, and Justice C.G. Mbogo. This is the land case petition number E052 of 2025. Justice issued on that judgment. This is a petition that was filed by Okia Umtata against the Ministry of Lands, Public Works, Housing and Urban Development, State Development of Housing and Urban Development, Director Slum Upgrading Development, Affordable Housing Board, Ministry of Environment and Natural Resources, Ministry of Roads and Transport, Honorable Attorney General, County Government of Nairobi City, National Land Commission, the National Environment and Management Authority, Ray Magan and Sons Limited, and Landmark Holding Limited. Langata reject. What was the facts in this matter? Paragraph 6 to paragraph 14 lays what was before the judge. It says, this urgency, he explained, is further heightened by the government's ongoing construction of social housing and associated infrastructure in Southlands Lang'ata constituency, Nairobi County. 7. According to the petitioner, Umtata, no public participation was conducted as required under the Constitution and the Environmental Management and Coordination Act. He maintained that the residents of Langata who stood to be directly affected by the development were neither informed nor consulted, and that the project was being imposed upon the community in total disregard to the principles of transparency, accountability, and good governance. Paragraph 8. Omtata said that excavation works had already commenced and were generating vibrations that had begun causing damage to adjacent residential houses in Southlands, Park 1, civil servants, Uhuru Gardens, and Maasai Estate. With respect to Lot 3 of the project, Omtata explained that the buffer zone adjacent to the southern bypass has been breached with excavated debris dumped against the backyard walls, resulting in excessive dust, noise pollution, compromised security, and loss of residential amenity. Paragraph 9. Omtata deposed that efforts to engage public authorities had proved futile. Further, that on 8 March 2025, Langata South and Estate Residents Association wrote to the Deputy County Commissioner, the Member of Parliament for Langata, and the Member of the County Assembly for Mugomoini Ward, but no responses were received, and that similar correspondence addressed to the County Executive Committee member for Built Environment and Urban Planning and the Principal Secretary for Housing and Urban Development likewise elicited no response. Paragraph 10. Omtata explained that via a letter dated 21st of March 2025, he sought clarification from the National Environmental Management Authority on whether the project had been subjected to environmental and land social impact assessment. Further, that NEMA confirmed in writing that no such assessment had been undertaken. But despite this confirmation, the regulator failed to hold the project and instead merely advised the proponent to comply with the law. Paragraph 11. He stated that on 8 May 2025, the Kenya Civil Aviation Authority convened a stakeholders engagement involving the chief executive officers of 48 aviation operators to deliberate on the project implications in proximity to Wilson Airport, and that the engagement confirmed that the development raised aviation safety concerns, notwithstanding the earlier exclusion of affected residents and stakeholders from the consultation. Paragraph 12. Omtata says the project site constitutes public land within the meaning of Article 62 of the Constitution. This is what we told you. This land is public land under Article 62, being designated a road reserve and a buffer zone. He maintained that its conversion into high-rise residential apartment amounts to unlawful alienation of public land and demonstrated a reckless abuse of power warranting judicial scrutiny. Paragraph 13. Turning to the infrastructure, Omtata averred that Langata was already experiencing chronic water scarcity and that the introduction of tens of thousands of additional residents without any water provision plan would exacerbate the crisis. He insisted that the existing sewer infrastructure was similarly overstretched, thereby posing serious public health risks. Lastly, he asserted that the scale and height of the proposed 17-story buildings will tower over surrounding mansionettes, homes infringing upon residents' right to privacy, and that no mitigation can assist. He therefore said this will change the social dynamics of the land. What did the government do? The government said through the affidavit of the Principal Secretary, Hinga, of Housing, that it is his duty to build housing, and they are implementing their constitutional mandate. The judges evaluated that evidence. What did the judge say. The three judges looked at and they started from paragraph 189, analyzing that. In paragraph 189, the judges say the evidence placed before the court show that activities on the project were already underway by March 2025. NEMA's own correspondence dated 26 March 2025 confirmed that as at that date, the project had not been subjected to environmental impact. The judges found out that the project started, construction started before NEMA certificate was issued. There was no evidence that NEMA had done that. Two, the ASIA report relied by the respondent are dated 20th August, that they are dated August 25th, and the license was issued on 16th December 2025. Can you imagine? The report was dated August 2025. The license to start construction was issued on 16th of December 2025, but the project started March 2025. That is a duration of over 9 months. This is what the judges are saying. This is the impunity in the affordable housing project. Paragraph 91. They said, further, upon examination of the ASIA report, the ASIA report was prepared by a consultant called Redseed. That report was not signed by the lead expert of the project. The lead expert by law is the one who signs. Paragraph 192, for lot number 3, the judges found out that the stakeholder engagement section refers to meetings held at XX without identifiable venues or verifiable minutes. These stakeholders allegedly who met, it's not clear where they met. My friend, every place in Kenya has a name. For lot number 2, the public barazas are alleged to have been conducted, yet no supporting evidence of notices, attendances, or proceedings. The barazas that were alleged to have been conducted, there was no notice to invite people. There was no list of attendance. There were no proceedings. There were no annexures. My God. Paragraph 193. Lot number 4 similarly lacks documentary proof of consultation, while the attendance list produced for lot number 5 refers to Mathare constituency. This is in Langata constituency. What was produced in court is for Mathare constituency. The distance between Langata and Mathare, my friend, you cannot convince the judges, raising doubts as to its relevance to Southlands Project, which is situated in Langata constituency. Paragraph 194, Regulation 17 of the Environment Impact Assessment Audit Regulation. Section 58 prescribes mandatory steps to be followed. They were not followed. Paragraph 195, Regulation 18.2 of the Environment Impact Assessment and Audit Regulations additionally requires us that the ESIA study report be signed by both the proponent and the environment impact assessment experts involved in this preparation. Compliance with these issues was not there. Paragraph 199, the judges are saying, while the respondents place considerable emphasis on the public funding of the project, the contractual exposure said to rise from delay because the government was talking of the delay and the contracts. At this stage, the judges found out that the court's view, these matters go beyond mere suspicion. And the judge found out that this construction did not comply with the provisions of the court. The court in paragraph 205 says, without making final findings, the court is satisfied that the petitioner has demonstrated on the face of the record a prima facie case with a likelihood of success sufficient to warrant further interrogation at the substantive hearing of this matter. The judges gave a thunder to anybody who has bought a property of affordable housing in paragraph 209 and 210. Public interest therefore tilts in favor of upholding the rule of law, environmental protection, and accountable governance, rather than permitting the entrenchment of a potentially unlawful status quo. In those circumstances, the court finds that the broader and enduring public interest lies in ensuring that any large-scale public housing initiative is implemented in a manner that respects constitutional safeguards and land use, environmental protection, and public participation. Such an approach preserves the integrity of public institutions, protects communal resources, and secures the long-term welfare of the populace. What are the judges saying? That governments must act within constitutional parameters. The government must act within the constitution parameters that safeguards land use. 2, environmental protection. 3, public participation. Kenyans are not passengers. This is what will protect communal resources. The communal resources, public land is a communal resource. So, the judges have ended by giving the final orders. A conservatory order does hereby issue, restraining the respondent, that's the government, their agents, servants, developers, contractors, assignees, or any other person acting under their authority, or whosoever acting from continuing with the excavation, development, and construction of social housing and associated infrastructure in Southlands Lang'ata constituency, Nairobi County, under contract provided. The officer commanding the station Lang'ata police station to provide all the necessary support required in execution of the orders granted. Dated and signed virtually by the three judges, Justice O. Angote, Justice C.A. Ocheng, Justice M. Bogo of the Environment and Land Court. What is the lessons in this matter? If you have bought land that was acquired illegally, if the process of acquiring that land to build affordable housing was not followed, like the Southlands Lang'ata issue, the judges will declare that a nullity, and the title deeds that you have will become a nullity. Wakili Danstan Omari, always bringing you the blockbusters as they are there. Keep watching. Enjoy your long holiday. 1st of June 2026.